Okay, council will go on the record in, this is Tresha Smith versus Bauer, case number 2319444. If I could have council put your appearances on.
Thank you. Miranda Bailey Quick on behalf of the petitioner, Tresha Smith.
Good afternoon, Your Honor. Attorney Stan Galdis for defendants.
Thank you. This is set for a status conference today. Ms. Bailey Quick on behalf of plaintiff, can you tell me?
Yep, so the probate matter has been resolved. We've been communicating with defense counsel and received the release, and we've provided the W-9. We're just waiting on a check and to send the release back, and just waiting on a dismissal to be able to sign, and that should conclude this matter.
Okay, Mr. Galdis.
That's my understanding as well, Your Honor.
Okay, Ms. Bailey Quick, when can we have that dismissal filed, do you think?
My understanding was, in reviewing the communication, was that defense counsel was going to email over the proposed dismissal, and we sent over the W-9, so we were just waiting on the check to send over the signed release. So that's, I guess I would defer to counsel.
Yeah, and thank you, Ms. Quick. It's procedurally speaking, I think it's just my understanding we typically submit the checks once the release is signed and received. So then we can notify our carrier where to send it, how to send it, and then the stip of dismissal can be filed on the same day, Your Honor. So as soon as we receive the signed release, we can get the stip and dismissal submitted. It's standard language, so I'm sure Ms. Quick won't have any issues, but we're happy to send it over to her. But I would think within the next 2-3 weeks, we should be able to get this thing wrapped up, Your Honor.
All right,
Okay,
and so I guess I'll take fault for that. We'll send over the release, and we'll send over the release today then.
All right, the court's going to put in the order here that the parties submit dismissal paperwork within 30 days. And that will be all. Anything else, Ms. Bailey Quick, that we need to address for the record today?
No, Your Honor.
Mr. Galdis?
No, Your Honor. I find no fault with Ms. Quick. I think it's just a matter of procedurally getting the authority for them to execute the release. So I think maybe that was some of the hiccup, but we're all set. So thank you, Your Honor, for your time, and thank you, Ms. Quick.
You're welcome.
Okay.
If you have a quick moment, if you'd like to give me a call, I have a few minutes.
Okay, certainly.
All right, great. Thank you. You're both free to disconnect at this time.
Thank you.
Thank you, Judge.
For the record, the preceding about 5 minutes was Smith versus Bauer, case number 2319444. Okay, we'll go on the record in Hammer Equipment versus Stuckman Tree Service, file number 2419661. Counsel, if I can have you put your appearance on.
Yes, Craig Mears on behalf of plaintiff from Hammer Equipment Finance.
Okay, thank you. This was set for 1:30. It's now 1:40 by my clock. I don't see any other counsel appearing today. Mr. Mearswa, can you tell me the status of this file right now?
Yeah, Jacob Stuckman filed bankruptcy, Your Honor, months ago. And the case is proceeding. I'll be a little bit slowly, but it is proceeding. So I did submit, I was looking back at my records. I did submit an order administratively closing the case. I don't think it was ever signed.
Okay, I will check with my office and see what the status of that is, because yeah, we definitely want to get that signed, so I don't keep dragging you in for these kind of status conferences. So
I would appreciate that. Yeah, that would.
let me just put you on hold for 1 second and let me check here real quick, okay?
Sure.
Okay, Mr. Mears, I did check with our office, and it does look like back on October 9th, the court did enter that order closing it.
Oh,
But it just didn't get closed in our system, which generated this status conference, but we're gonna make that correction. So the court won't schedule any further dates until we get notice that the bankruptcy is resolved.
excellent. Thank you very much. Yeah, I appreciate that. It was, I look back, it was submitted on October 1st to the court. So I appreciate that, Judge. And yeah, if something happens and, you know, Mr. Stuckman doesn't get a discharge, we'll be back before you in furtherance of judgment enforcement.
Okay, sounds good. Thank you. And you are free to disconnect.
Thank you very much. Have a great day.
Next hearing set for 2 o'clock. We'll be in recess until that time. All right, Mr. Legal, are you able to hear me okay?
I am, Your Honor, yes.
Okay, great. We'll go on the record now. This is Salo versus the Michigan Secretary of State, file number 2519969. Mr. Legal, if you could just put your appearance on.
Kyle Legal on behalf of Albert Salo.
This is set for a hearing today. Mr. Salo's driver's license was suspended as part of a OWI arrest and a first implied consent suspension. This is a hardship appeal of that. Mr. Legal, I did have a chance to review your motion and the facts supporting that. I also am in receipt of an assessment from Catholic Human Services, which I had a chance to review today prior to the hearing. Did you want to take some testimony from your client today, or how did you want to proceed?
Yes, Your Honor.
Okay. Mr. Salo, if you can raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, thank you. You can lower your hand, and Mr. Legal, whenever you're ready, please proceed.
Thank you. So, Mr. Salo, you were arrested on December 22nd of last year, is that correct?
Yes.
And you did not take the blood test, is that correct?
Yes.
Okay. You immediately involved yourself in counseling, is that correct?
Yes.
Okay. So what are you doing right now as far as counseling goes?
I'm doing group counseling, and I'm doing in-person counseling.
Okay. And have you drank since that offense?
No.
And what do you currently do for work?
I work at Blarney Castle Easy Mart, West Side.
Okay. And you also have another business too, is that correct that you do?
Yes.
Okay. And what else do you do then?
Irrigation service work during the summer.
Okay.
It starts the end of April.
Okay. Is that an employment that you could do with public transportation?
No.
Do you have any friends or family that could help you
No.
make all those trips?
No.
Okay. And how many children do you have? 4.
With one on the way.
Okay. Your current employment, do you think that's something you could do through public transportation?
Not currently.
Okay. And is it also correct that you were arraigned today on the underlying matter that you got arrested for?
Yes.
Okay. And on Wednesday, you have a meeting with Luke Hamlin from the recovery court. Is that correct?
Yes.
Okay. All right. And at this time, you're not drinking and not intending to go back to drinking. Is
No.
that correct?
No.
All right. Thank you. All right. I have no other questions for Mr. Salo, Your Honor.
All right. And Mr. Legal, it looks like in addition to the December 22nd arrest, that there was one prior OWI in July of 2023. Is that correct?
That is correct.
Okay. And do you know what the outcome of that was? Was that prosecuted and what the results were?
That was an impaired driving was the final result. Did you have probation on that?
No.
All right. And I don't think he had probation on that matter. He was arraigned this morning. The prosecutor's office said that they are recommending him for this recovery court. So he is meeting with Mr. Hamlin. And that's one of the big reasons we want to try and get this suspension lifted, because through the recovery court, he'll have an opportunity to get an interlock in his car. And we didn't want to prevent his ability to drive if he's able to get that interlock in his car.
Okay. All right. Anything you wanted to say, Mr. Legal, in support of the petition here?
Yeah, we just asked the court to allow him to have those standard restrictions that are available on the court form. Has kind of the standard restrictions driving for employment, for any medical appointments, as well as any court processes. He's been suspended now without his license. This went into effect in the middle of January, so he's already had almost 60 days worth of this. And again, our goal here is to get him into that recovery court, hopefully get him on the interlock once he's served his time through the recovery court, so that he's able to work and take care of his family.
Okay. All right. As I said, I had a chance to review the documentation that was submitted. Mr. Salo, your testimony here on the record was consistent with what was presented in the documentation. I think my biggest concern at this point, I think arguably there's a hardship here based on employment. I think my bigger concern is, frankly, some of the information that I read in the alcohol assessment that was done by Catholic Human Services. And so I think in the interest of public safety, And given the status of your underlying case, which I'm sure you're subject to a bond condition, which probably provides for some alcohol testing. But because you're not on probation yet, it sounds like you've just been arraigned. I'm not satisfied, again, for the sake of public safety, that there's adequate oversight of you at this point for me to be willing to reinstate your license even on a restricted basis. However, what I would propose, Mr. Legal, is that the court not rule one way or the other on the petition at this point. I think if Mr. Salo is coming back to me, in 30 days or whatever it is, that he's determined to be eligible, participating in the treatment court, I think that's a different story. I mean, I think at that point, there would be adequate oversight. I think for hardship reasons, if he's going to be eligible for an interlock through the treatment court, I wouldn't want this to stand in the way of that, because number one, I think, it would affect Mr. Salo's ability to work, pay for probation and his participation in the treatment court. And I think the treatment court is something that would likely be of benefit to him and to the entire community. And I wouldn't want the implied consent part of it to get in the way of his ability to use the interlock through the treatment court program. So I'm not prepared to grant the petition today. I think the options are either the court would deny it today or the court would reserve ruling on this. And Mr. Legal, if you wanted to renotice this for a time after there's a decision by the treatment court, then I would reconsider it at that time. So I think I know where you would go with it, but I wanted to give you the options.
And I did talk to Mr. Salo. That might be a potential option too, is adjourn this out a little bit to allow that case, because they had to send his blood to the lab. It took a little bit of a lag, so the court case is just catching up. So we certainly would have no issue with adjourning this, allowing to see where he goes with the recovery court application, and then coming back before Your Honor.
All right, so I'm going to set this out for another hearing in 60 days. If for some reason that part of it's resolved and you want to get in front of the court sooner than that, Mr. Legal, then just ask for a date from Jennifer and try and get it in sooner, but that'll be the next date. And then let's see where we're at that point.
Yes, Your Honor. Sounds good. Thank you.
Okay. All right. Thank you. That's all for today. And you're free to disconnect at this time.
Thank you.
Okay, we're in the record in Chapco versus Guy. This is file number 2419874. If I could have counsel put your appearances on, please.
I'm on behalf of Rachel Chapco, who's present seated to my left.
And Jonathan Baber on behalf of Mr. Guy.
Okay, this is set for an evidentiary hearing on an alleged violation of the personal protection order in this matter. Mr. Guy was previously arrested for that violation, was arraigned and appointed counsel. Mr. Baber, does your client wish to proceed with the contested hearing today?
Actually, Your Honor, just to make the court aware, unfortunately, the first time I was able to speak with Mr. Guy was approximately 8 minutes ago in regard to this case. I did send out a couple mailers to his house and some phone calls. He indicates he got the first mailer, I think, just a couple of days ago in the mail from my office. He also indicates to me that there's some paperwork he received from his court that he does have in his truck that he wants to review before anything happens today in regard to this case. I'm asking this court to consider an adjournment. I was actually prepared to come here today, not knowing where Mr. Guy was, to perhaps be doing a motion of withdrawal just based upon the lack of communication and my inability to proceed without communication with my client. But I think an adjournment in this case could be appropriate. This is our first time up here. Mr. Guy does have some health issues that I can attest to just on my brief interactions with him that may explain why it was slow for him to get in touch with me. I do not believe he's been in any violation since his arrest and arraignment in this particular case. I don't believe there's any threat to the plaintiff in this matter. Should we have another adjournment to give me an adequate time?
Thank you, Mr. Vernon.
Your Honor, I understand the reason for the request to adjourn. We're opposing that request. Every time we come here, it costs Ms. Chapco money and time away from work. It costs the staff that has to appear more time and money. This is not the first time for Ms. Chapco to appear. It's not the first time Mr. Guy had to appear. This is the first time that Mr. Baber had to appear. With regards to the issues, and Mr. Baber's suggestion that there's not a threat. The reason there was PPO in place is because there's legitimately a threat. That has not dissipated. This has in fact increased to the fact that Mr. Guy can't seem to comply with the court's previous orders. He still shows up at her place of employment with no reason for being there. So the risk is greater now than it was. The expenses continue to accumulate for the one person here who's done nothing wrong, and that's Ms. Chapco. So we would ask the court to take proofs today. Maybe if Mr. Baber wanted, a 15, 20 minute, half hour to go over these things. I mean, the police report is a page and a half. It's not factually intensive. I just would really rather not have to reschedule this, come back up here and bill again for the same thing.
Yeah, so I mean, this matter was set for a hearing today. Mr. Guy was aware of this hearing. He was appointed counsel. Mr. Baber, I understand the position that you're in, but in my view, your client, for whatever reason, has chosen not to get in touch with you and not to make himself prepared for the hearing today. So I don't view it as, you violating your duty in any way. You've reached out and tried to reach him, and your clients, particularly in the position that you're in as a public defender, sometimes cooperate, sometimes they don't, and the degree to which they cooperate sometimes is unfortunate. But Mr. Guy, this is no big surprise here. I think what Mr. Baber is indicating to me in terms of your actions are consistent with the way you've kind of been looking at this all along, which is, I think, without an adequate amount of attention and seriousness on your part. And you've chosen to do that. So you're going to have to bear the consequences of your own decisions here in not getting in touch with your attorney so that he could be prepared to present your case. Also, I agree with Mr. Vernon. I mean, this is not a particularly factually complex set of circumstances here. The order is what it is. And Mr. Vernon's got the burden of going forward today as the party alleging the violation. There isn't a lot of discovery to be had or done. So I also agree with Mr. Vernon's statements that this is going to pose further inconvenience and costs on the petitioner, which aren't warranted. So we're going to proceed with the hearing, Mr. Baber. I will give you a minute or two if you want.
Just after briefly talking with my client, maybe we briefly. He just wants an opportunity. Which
So I just had a discussion with counsel at the bench. Mr. Baber, you indicate that your client is now willing to enter into a no contest plea.
That's correct, Your Honor.
Mr. Guy, is that correct?
Yes, sir.
Okay. So, and Mr. Vernon, you don't have an objection to that?
I do not. Mr. Baker, you agree that the police report is the appropriate?
Yeah, I've reviewed. There's no objection.
Okay. It's 2 pages, they're not stapled. I only put the sticker on the first page.
So, Mr. Baber, if you and Mr. Guy can come up to the podium, please move that over. Thank you. Mr. Guy, I'm going to go through a few things with you here with regard to your rights, okay? First, can you raise your right hand? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Mr. Guy, you understand that you have the right to have a hearing as to whether or not you violated the personal protection order? Okay. You understand that by pleading no contest today that you're going to be giving up that right?
Yes, sir.
You understand that the maximum possible penalty that you could face for violating a personal protection order is up to 93 days in jail and or a $1,000 fine. Do you understand that?
Yes, sir.
All those things in mind, is it your wish to plead no contest today?
No contest, sir.
Has anyone threatened you with anything to get you to enter this plea?
No, sir.
Has anyone promised you anything?
No, sir.
Is it your own free choice to enter into this plea?
Yes, sir, it is.
So I did review the police report prior to the hearing today. Mr. Vernon, have you reviewed that?
I have.
Okay, and I'm referring to case number 25169000091. That's the report of the Otsego County Sheriff's Department. Mr. Vernon, would you agree that the information contained within that report would constitute a violation of the personal protection order?
I do, Your Honor. I would specifically point to the section where the contact with the offender, where Mr. Guy was present on the protected person's business property or work property, that he identified that he was there to see his good friend Rachel Chatko. It identifies that he had no reason to be there. In the contact with staff section, that he had no reason to be there, that he had been previously discharged as a patient from there. And the only reason for his being there was to see his good friend Rachel Chatko, which is clearly a violation of the order.
Okay. And Mr. Baber, would you agree that that report would form a factual basis for finding of guilt?
That report would find a factual basis.
Okay. So the court is going to mark, or actually Mr. Vernon has marked that the court will admit it as plaintiff's exhibit 1, or will attach that to the file as the factual basis. Mr. Guy, the court finds that your plea is knowing, voluntary. The court finds that based on that information, there is a sufficient factual basis to support a finding that you did violate the order in this case. The court will accept the no contest plea. In terms of sentencing, Mr. Vernon, is there anything that you want to say today?
Your Honor, I know that this court has a general policy of imposing a fine on a first violation of the PPO. I don't view this as a first violation of the PPO. This is actually the the second time that this has happened, just because of the way that the PPO was put in place. There was the notice to no longer appear at Ms. Chapco's place of work, the motion to terminate, and in that time, he'd actually appeared again. So this is actually the second time he's been in violation of that instruction and not go to her place of work. So we would ask the court to consider some period of incarceration as a penalty. I think I would agree with what the court had said previously, which is that Mr. Guy doesn't seem to be taking this very seriously. The allegations that were set forth in the petition are significant and serious to Ms. Chapco, in that Mr. Guy wanted an intimate relationship with her that he suggested taking her away. I think there are some risks there, and I think those need to be followed through on. I mean, the fact that he told this court he had no interest in going back there at his motion to terminate. When the court denied, he said he had no interest and no reason to go back there, and we find him there again. So I see that the level of risk to Ms. Chapco continues to increase. And I think we need to find a way to impress upon Mr. Guy that that's not okay.
Ms. Chapco, you have an opportunity to address the court here as part of sentencing. Did you want to say anything to that?
She indicated she does not wish to speak.
Okay. Mr. Baber, anything on behalf of your client?
First, on behalf of myself, I apologize for not having my phone in airplane mode.
Actually, I didn't even notice that I was listening to these guys.
Okay, well, regardless, I try not to make that mistake too often in my career. But what I can say is that this is truly the first technical violation of the PPO. My client is before this court for the first time on this. And I do believe that this case has impressed upon him an understanding that the PPO is still in place. As I said in my brief conversation with him, he discussed receiving paperwork from the court approximately a week after he was served with the original PPO, and he may have misinterpreted what that paperwork necessarily meant. When I talked to my client, he said if I knew the PPO was still in place, I wouldn't have gone back to that place of business. And when he indicated to me his desire to do a no contest plea, he said, if this will make the plaintiff feel safer and we can get on with this, I want to do the no contest plea. I know the factual background of this case primarily from reading the reports. To me, this is a situation where my client did have a sense of affection towards the plaintiff in this case, and for lack of a better term, I think he shot a shot, attempting to profess that desire to have a relationship beyond professional with her, and ultimately, I think he pursued it longer than he probably should have, given the indication from the plaintiff that she didn't reciprocate those same feelings back. But I don't believe my client still holds those same feelings and desires. I really do not believe that he's going to be a continuing threat to the plaintiff in this matter going forward. And I believe this court even here can verbally let my client know that PPO is most definitely still in place. He still most definitely cannot go to her place of business, have any communication with her, and that the next time you violate it, it is going to result in a sanction of jail, as this court routinely does on the second. So I'm just asking the court to follow through with what it normally does and just have this be somewhat of a shot across the bow and allow my client to prove himself.
Thank you. Mr. Guy, is there anything you wanted to say today?
I am sorry, sir, and I'm recovering from norovirus. I'm getting over it this weekend. I've had a better part of last week. I'm having a hard time with my medical problems, but I've never intended to hurt anybody. I just wanted to tell her, but like I said, as soon as I can clear money to leave here, I am. I am not a threat. I beg of you to believe me. That's all I can say, sir, is I'm sorry. I am sorry.
Okay. All right, well, I'm obviously familiar with this case. We had a hearing previously on your motion to terminate. And part of the reason why I didn't terminate it, and I think I made the statement to you on that day, is that I didn't think you were taking this seriously. And I didn't think that without that order in place, you wouldn't try to contact Ms. Chapko again. And even with the order in place, you did that. So I do think that there's a basis for finding that you did violate the order in this case. I do think there's a basis for Ms. Chapko to be concerned that you aren't going to comply with the order. The flip side of that is that this is the first finding that you violated the order. And typically where it's a first finding of that and where the violation did not involve any kind of assaultive or directly threatening kind of behavior, the court does impose a fine for the exact reason that Mr. Faber indicated, which is to give you an opportunity to understand that this is serious. I will note that, you know, you were arrested on January 14th in the afternoon. You spent the night in jail because you weren't released until the 15th. So you did get a taste of what it's like to spend the night in the Otsego County Jail. I'm sure that wasn't a pleasant experience. I don't want to put you in jail because of your physical condition, but if you continue to violate this order, you're not going to leave me with any choice, because I'm not going to continue to allow you to violate the order without the punishments increasing as we go and as you continue to do it. So I want you to be very clear that there won't be any excuse or reason for me to not put you in jail if you violate this order again and you're found guilty of that. Do you understand that?
Yes, sir.
Is there
You'll
anything
never,
about what I'm saying that's not clear to you?
you'll never see me again,
All
sir.
right, that's fine. The other person, the more important person who should never see you again is Ms. Chapko. All right.
Never will. sir.
So this order is in place. It's going to be in place. You need to stay away from her. And if you want to avoid going to jail for longer than one day, this is your last chance to do that. Based on the violation here and the circumstances, the court is going to impose a $250 fine along with $100 in court costs. And after this hearing, you need to go downstairs to the clerk's office to make arrangements to pay that fine.
Yes, sir.
Mr. Burke.
You know, would the court consider imposing some restitution for my client's attorney's fees and loss of work for today?
I don't know if you can. I don't believe the statute allows for restitution.
I think the Crime Victim Rights Act is
Part of contempt. So.
I think the Crime Victims Rights Act.
I don't necessarily know if that applies to a situation like this, Judge. I would have to definitely do some heavy research on that.
I mean, this is a contempt charge. So if you want to, you know, let me take a quick break and see if that's something.
I mean, if the court wants to give me 14 days to file a brief, if
But
it's
then
appropriate.
the problem is if you're not, if Ms. Chapko is not entitled to it, then you're going to have to incur more fees. So let me just take a short recess here. Okay, Ms. Wright, are you able to hear me okay?
Yes, I can hear you.
Okay, we're on the record now in the matter of unpaid property taxes in Otsego County. It's file number 2519968. Present here today by Zoom is the Otsego County Treasurer, Paula Wright. This matter was set for hearing at 2:45. It's now almost 2:50. I don't see anyone else appearing in the Zoom waiting room. Ms. Wright, you're asking the court to enter an order with regard to unpaid property taxes for the years of 2013 through 2018. Is that correct?
Correct. It's the personal property taxes that have been uncollected for that long, and most of those businesses are no longer in business, so.
Okay, is there anything else that you wanted to state for the record in support of your petition here today?
No, just that we had sent notices. We sent certified letters to the schools, letting them know how much they would be losing. It's not money that they've been paid, so it's not anything they have to pay back. And then we also gave notice to all of the millage units. So that everybody is aware of the amount of money that would be uncollected and written off for them.
Okay. All right, I did review the file. It does appear that all the proper notices have been sent out. Again, no one has appeared here today to contest the relief requested, so the court will sign that order. Is there anything else that I can address for you here today while we're on the record?
Nope, that was all, Your Honor. Thank you.
Okay, thank you. That order will be available in the clerk's office.
Okay, have a good day.
Thank you. You're free to disconnect.
Thank you.
Okay, let's see here. It looks like we have everybody connected. So let's go on the record. This is Kalkaska County case number 2414652. And if I can have counsel put your appearances on, please.
Melissa Umulis on behalf of plaintiff Joy Verdi Spansky. Good afternoon, Your Honor.
Afternoon, Your Honor. Jonathan Tomas on behalf of the defendant, Roger Spansky, who was also appearing this afternoon via Zoom.
Okay, and I see we have the parties connected. This was set for a status conference today. However, I am in receipt of a proposed consent judgment of divorce. Ms. Umulis, did you want to proceed to take proofs and finalize the divorce today?
Yes, Your Honor.
Mr. Tomaso, is that where your side is at as well?
Yes, Your Honor.
Okay, so folks, if I can have you unmute, please. Here we go. And are you Joy Verdi Spansky?
Yes, I am.
And are you Roger Spansky?
Yes.
Okay, I'm going to ask both of you to raise your right hands, please. Do you both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Yes.
Thank you. You can lower your hands. Ms. Umulis, whenever you're ready, please proceed.
Thank you. Ms. Verdi Spansky, could I have you state your full name for the record, please?
Joy Lynn Verdi Spansky.
And you were married to the defendant on April 26th of 1996, is that correct?
Yes.
And you filed a complaint for divorce on or about November 25th of 2024?
Yes.
And at the time you filed your complaint for divorce, had you resided in the state of Michigan for at least 180 days before filing?
Yes.
And at the time you filed your complaint for divorce, had you resided in the county of Kalkaska for at least 10 days immediately before filing?
Yes.
And you and Mr. Spansky do not have any children together, is that correct?
That is correct.
And you're not currently pregnant?
No, I'm not.
And has there been a breakdown of your marital relationship such that the objects of matrimony have been destroyed?
Yes.
And do you believe that there's any likelihood of reconciliation between you and Mr. Spansky?
No, I don't.
And you and Mr. Spansky reached an agreement regarding division of your marital assets and liabilities, is that correct?
That's correct.
And that agreement is set forth in the terms of your judgment of divorce and property settlement agreement that have been submitted with the court?
Yes.
And have you had an opportunity to review both of those documents?
Yes, I have.
And do you fully understand the terms set forth in each of those documents?
Yes, I do.
And do you believe that the terms regarding your division of marital property to be fair and equitable?
Yes, I do.
And pursuant to your agreement, neither you or Mr. Spansky is awarded spousal support, correct?
Correct.
And do you understand that that agreement is final and binding and that neither one of you could petition the court for spousal support in the future?
Yes, I do.
Okay, and at this time, are you asking that the court grant a divorce?
Yes, I am.
Thank you. Nothing further, Your Honor.
Thank you. Mr. Tomaso, did you have any questions for Ms. Verdi Spansky?
No, Your Honor.
Okay, did you want to take any testimony from your client?
Very briefly, Your Honor. if I may.
Okay, proceed whenever you're ready.
Thank you. Mr. Spansky, can you please just state your name for the record?
Roger Spansky.
And did you have a chance to review the proposed judgment of divorce and property settlement agreement?
I have.
And do you understand the contents of those documents?
I do.
And do you agree to be bound by those documents?
I do.
Do you understand that you're not asking for spousal support and that would be forever barred, so you would not be able to come back and ask the court for spousal support at a later date?
That is correct.
And finally, you had the right to a trial where you could have done better, worse, or possibly a similar outcome, but you would ask to waive that and that the judgment be entered today. Is that still true?
That is correct.
Your Honor, I wouldn't have any more questions.
Thank you. Ms. Umulis, do you have any questions for Mr. Spansky?
I do not.
Okay, the court finds that the statutory grounds for divorce have been met by the testimony of parties. The court has reviewed the proposed judgment of divorce and property settlement, finds that it's generally equitable, contains all the provisions required by law. The court will grant the divorce. I'm signing that judgment with today's date. Ms. Umulus, on behalf of plaintiff, anything further that we can address for your side today?
No, Your Honor, thank you.
Mr. Tomaso?
No, Your Honor, thank you very much.
Okay, that's all for this hearing today, and all parties are free to disconnect at this time.
Thank you. Okay, Mr. Blumberg, do you have Ms. Carr present with you there?
I do, Judge. I just want to make sure you're still talking to me after this morning.
What? That's a big deal.
No, I just want to make sure.
Okay, and it looks like we have Mr. Carr connecting here. Mr. Carr, you're going to need to go into your Zoom app and connect your audio. Okay, all right, Mr. Carr, now you just need to unmute, please.
Yes, sir.
All right, great. So we have Mr. Carr connected now. Mr. Blumberg's present on behalf of his client, Alma Carr. This is file number 2419798. I believe this is a first status conference here. It looks like Mr. Carr was defaulted. Is that right, Mr. Blumberg?
Judge, I know that he hasn't filed any responsive pleadings and the action was filed in August. I don't know whether a default has been entered or not. I don't see that in my file.
Okay. It looks like there was a default entered back on October 28th.
Well, okay. I guess I can report to the court that in spite of that, the parties have been communicating. And I think the parties will come to an agreement on all of the issues. And so while the judgment has not been completed yet, would the court be inclined to allow us to place the proofs on the record, or would that be for another day?
I think we can do that. Mr. Carr, do you agree that any issues regarding the assets or debts of the marriage have been resolved?
I mean, as far as I know, we've been working on it really hard, Your Honor. And as far as the default goes, when I moved, I thought I forwarded my address, but I didn't receive any other paperwork other than when I was served my initial, served papers. So I did get for the Zoom meeting, but I didn't receive the other one. I have no reason to default on you or dishonor the court like that.
Okay. All right. Do you agree that things are resolved so that or are there from your
I couldn't tell you if they're fully resolved or not. I mean, as far as the disallow the property and everything, we've agreed on when we sold the house that it was 50-50. I kept my truck and all the marital debt. I kept my credit card and all the marital debt. I bought a new house. but I mean, as that's what we're standing on that, and all our property was split up amicably and even.
Okay. All right, so Mr. Blumberg, I guess let's take proofs from your client. If there are issues that arise, then we can always schedule further hearings if we need it.
Great.
So Ms. Carr, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can lower your hand. Go ahead, Mr. Blumberg, whenever you're ready.
Thank you. Alma, could you state your full name for the record?
Alma Clarissa Carr.
And you are the plaintiff in this action for divorce, is that correct?
Yes.
You had filed a complaint for divorce in August of 2024, and in it you alleged that on November 23rd of 1990, you married Mr. Carr in Crawford County, Michigan. Is that correct?
It is correct.
And that marriage was performed by an individual who was authorized to perform marriages. Is that correct?
Correct.
And you also alleged in your complaint that you had been a resident of the state of Michigan for at least 180 days before you filed your complaint. Is that correct?
That is correct.
And that you were a resident of Otsego County for at least 10 days immediately preceding the filing. Is that also correct?
Correct.
There are no minor children of this marriage, correct?
Correct.
And you allege that there had been a breakdown of the marriage relationship to the extent that the objects of matrimony had been destroyed, and there remained no reasonable likelihood that the marriage could be preserved. Was that true at the time that you filed?
Correct.
And is that true today?
Yes.
You understand that neither you nor your husband are seeking spousal support in this case. Is that correct?
Correct.
And do you and Mr. Carr both understand that you're not going to be able to come back to court at a later date and ask the court to award spousal support?
Correct.
Okay. And again, you and Mr. Carr have divided up the assets of the marriage. The marital home was sold, and you and he split the proceeds from that sale. Is that correct?
Correct.
Have you and he are currently living separately. Is that correct?
Correct.
Okay. Has the personal property of the marriage been divided in a fair and equitable manner?
Yes.
Okay. I need to ask you this. You are not currently pregnant, are you?
No.
Okay. Is there any likelihood that this marriage could be preserved?
No.
And ultimately, once the judgment is prepared and signed, are you asking the judge to adopt the division of both the assets and the liabilities of the marriage in a fair and equitable manner? Okay, thank you. I have nothing further, Judge.
All right, thank you. Mr. Carr, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Thank you. You can lower your hand. Mr. Carr, did you hear all the questions that Mr. Blumberg asked of Ms. Carr?
Yes, sir.
And did you hear all of her answers?
Yes, sir.
Do you have any reason to believe that any of the answers she gave were untrue?
No, sir.
All right, and you've indicated here a little bit earlier today that you believe all the issues relating to the division of the property have been resolved. Is that correct?
Yes, sir.
Okay. And you understand that as part of the divorce, you also won't be receiving any alimony or spousal support?
Yes, sir.
And as with Ms. Carr, you understand that you'll also be waiving that and you can't come back later and ask the court for that?
Yes, sir.
Okay. Mr. Blumberg, did you have any questions for Mr. Carr?
I do not, Judge. Thank you.
Okay. All right, the court finds that the statutory grounds for divorce have been met by the testimony of the parties. The court will grant the divorce. Mr. Carr, it sounds like Mr. Blumberg is going to prepare a judgment. That's the final document that finalizes the divorce. So until that's signed, it won't be finalized, even though we've taken the testimony and had the hearing today. Do you have any questions about that?
No, sir.
Okay. I say that because that's an important final step to follow through with, because again, what we've done here today doesn't finalize the divorce. It's the signing of that judgment that does. So, Mr. Blumberg, anything further that you need to address from your side today?
No, Judge. Thank you. I don't believe so.
Okay, thank you. That's all for this hearing today, and both parties are free to disconnect at this time. Okay, looks like we have both counsel connected, so we'll go on the record. This is Robinson versus Pruskevich and the Otsego County Road Commission. This is file number 2419938. If I could just have both counsel put your appearances on, starting with plaintiff, please.
Good afternoon, Your Honor. Jason Hodge appearing on behalf of the plaintiff, Michelle Robinson.
Good afternoon, Your Honor. Adam Tuntis appearing on behalf of the defendants.
Okay, we're on the record here today for a scheduling conference in this case. Mr. Hodge, can you just tell me a little bit about what your claims are? It looks like this was an accident between a county plow and a vehicle, is that right?
That is correct, Your Honor. Yeah, so and she sustained injuries as a result of that accident, including what appears to be some kind of head injury, along with neck and low back injuries and some other miscellaneous ones. But those are the three kind of big ones that she sustained as a result of this incident.
All right, and is she still undergoing treatment? Is her medical still ongoing?
As of right now, yes, it is still ongoing. And when I looked at the file, it looks like she's still treating with Michigan Spine and Brain, which is in Mount Pleasant, I believe, where she's receiving injections for her head pain, ongoing kind of headaches and all that stuff, as well as some low back pain.
Okay, all right, thank you. Mr. Tuntis, anything unique or different from your standpoint in terms of the defendant's position?
I don't think so. I think the injuries are surprising to me, quite frankly, given the severity of the crash. And so medical discovery is going to be really important. And I would just want to ensure that we have enough time to get a full complement of our medical records, go through them, get them in the hands of somebody who can give us their take, possibly do an independent medical examination or two, depending on the circumstances.
Okay. How much time do you want for discovery?
I would like 6 months if the court would give it to me.
All right. Mr. Hodge?
6 months is perfectly fine. We have no objection to that.
All right, so we'll set a 6-month period for discovery. Mr. Hodge, from plaintiff's standpoint, is everybody in that needs to be in? Is there any need to amend pleadings or add any parties?
No need to amend as of right now, and I don't anticipate any surprises during discovery that would warrant a need. But who knows? I guess, but I don't think anything like that will happen, Your Honor.
Okay, Mr. Tuntis, are you guys going to try to bring anybody in?
No, Your Honor.
Okay. All right. Do either of you have any objection to facilitated mediation at some point within the time for discovery during that 6-month period?
We would love to do facilitated mediation. We would actually request, would it be possible to do that after the close of discovery?
Any objection to that, Mr. Tuntis?
I don't.
Okay. So we can say, let's say mediation to occur within 60 days of the close of discovery.
That sounds great, Your Honor.
Okay. And Mr. Hodge, have you worked with Mr. Tuntis before? Do you think you'll be able to agree on a mediator in this case?
I've not had the pleasure. However, I'm sure we can agree on a mediator. Yeah.
I'm sure we'll be fine, Your Honor. He looks like a great guy.
Okay. So I'm going to indicate for the scheduling order that even though it's going to be a ways off, that the two of you confer and agree on a mediator and notify the court in writing of your selection within the next 30 days.
Sounds good.
It sounds great.
And then what I typically do in these kind of cases is rather than, doing a lot more scheduling early on, I like to set a status conference for right after mediation or the mediation cutoff to see where the parties are at. And then we can discuss at that point some cutoffs for dispositive motions. And of course, either or both of you are free to file dispositive motions at any time, but we can set some cutoff dates for those. And then, but to the extent that either of you want to file those even prior to mediation on, C8 issues or C7 issues, to narrow things for mediation, we can do that. But we'll set dispositive motion cutoffs at that point, and then look at whether further ADR is contemplated or whether we want to set trial dates. So that's kind of how I do things. So I'll be setting a Zoom status conference like we're doing today around the cutoff for the mediation, which would be 60 days following discovery. So, Mr. Hodge, any other dates that I can address for your side in terms of scheduling today?
Nothing for the plaintiff, Your Honor.
Mr. Tuntas?
Nothing for the defense, Your Honor.
Okay, so I'll put these dates into scheduling order. That'll go out to both of you. The court will also send out a notice of the date and time of that next status conference. And we'll go from there. Thank you, and you're both free to disconnect.
Thank you,
Thank you, Your Honor.
Nice to meet you, Jason.
Nice to meet you as well.
Okay, for the record, that was Robinson versus Prusakevich, file number 2419938. I just clicked it now, but the previous 5 minutes or so was the status conference. That concludes the court's afternoon docket today. The court will be in recess until 9 a.m.